This is an introduction to some basic concepts of judicial review that I thought it might be helpful to set out for you in some simple form. So first of all, just wanted to mention the forms of judicial review. I included in the readings a piece about judicial review that included just a little bit about New Zealand, because in different countries judicial reviews have different status. In some countries the judiciary actually has the power to strike down legislation. This is where there is some form of entrenched or supreme law, the US Constitution being the obvious one, where the courts have the specific role of maintaining, being the guardians of that constitution. So every single decision or rule or law or whatever that's made by local states or counties or any public body has to be consistent with that constitution. And the court's role is to ensure this. That means even laws, decisions made by the president, made by Congress, everything has to be consistent with that constitution. Now, New Zealand has nothing, no supreme law like that. The only law that exists in New Zealand can be overturned by any government. By any government with a one-seat majority can change any law in New Zealand. So the courts don't have any firm, clear, independent guide to what they do or rule book they have to follow, and as a result the judiciary in New Zealand doesn't have that strong power that it has in other places, and the judicial review we find in New Zealand was a comparatively weak form of it. Now, the actual legal basis for judicial review in New Zealand is found in a statute. Parliament passed a law that provides New Zealanders legal recourse against decisions made for public purposes by public bodies. And that legal basis can be found in the Judicial Amendment Act 1972. There's been a couple of amendments since then. But of course, judicial review predates 1972. What happened is that act codified in statute, so wrote down in statute, a legal process that actually has far more ancient origins. And here we're getting right back to ideas about common law. That at common law, there is this long-standing principle that public bodies need to be accountable under the law, that the law applies to everybody, and that the courts can hold public bodies to account. And the origins of that goes right back to this case in 1765 of Entick and Carrington, where the king sent in some of his guards to basically turn over the home of somebody he thought might have been writing things against him, to see if he could find some evidence against him. That person took the king's agent's court, and the court upheld or made a ruling that was unlawful, that it was a breach of the rights of this person to be invaded in this kind of way, even by the state. So this was the point where state agencies effectively became accountable under the law back to the people. So whose decisions are reviewable by judicial review? Well, all sorts of decisions. Ministers of the Crown, and those examples I've given you, the Ministry of Education or the Minister of Education or the Environment Minister, all sorts of ministers, public bodies, officials, local councils, all decision makers who are exercising public functions or impacting on the public. So the scope of judicial review, even though it is relatively weak, is quite extensive. It covers a lot of functions. Definitely all public educational institutions, all schools or universities, wānanga, polytech, are all, as public bodies, have their decisions potentially able to be reviewed by the courts. What about private educational institutions? Well, it's an interesting question. Are private schools, private educational institutions exempt? In overseas jurisdictions, they often are. They generally are exempt. But it looks as though they probably aren't in New Zealand. And I say probably aren't because this is, again, this example of the statute sets out what can happen, but it doesn't say that that private institutions can't be held account. It sets things out in general terms. Have a look at that Act if you like. And how we know about this is because of Court of Appeal judgments. And here's a couple that speak to this in particular. One of them, this Court of Appeal judgment in 1999, said over recent decades, courts have increasingly been willing to review exercises of power which in substance are public or have important public consequences, however their origins and the persons or bodies exercising them might be characterized. So, irrespective of how the decision makers are characterized, if their decisions have important public consequences, then they too can be judicially reviewed. This was built upon a bit more in this case, another Court of Appeal case, 2005, Wilson and White. The principle is that the courts, in considering the amenability of administrative action to judicial review, are less concerned with the source of the power exercised by decision makers, and in particular whether or not it was statutory, and now more ready than in the past to treat as reviewable the exercise of any power having public consequences. This is so even if the power is exercised by a private organisation. So what this has been interpreted to mean is that it's likely that very likely that integrated schools, and probably likely also that private schools and other private educational institutions could have their decisions judicially reviewed, but we don't know for sure because we only know if somebody applies for a judicial review and they're against, say, a private school, and then the private school responds by saying, you can't review us because we're not a public institution, and the court makes a finding on that, makes a ruling on whether this case is able to be brought against them. So this is how common law kind of plays out in practice. The indications are probably private institutions would be included, but we don't know for sure. Now, judicial review, you need to remember that it is quite distinct from an appeal, in the sense that judicial reviews examine the manner and process by which decisions are made. So they don't sit down and make decisions for the decision makers and say you got this wrong. In substance, they look at the way in which the decisions were made. And this was spelled out by the case in this Aorangi School case that I gave you a copy of by Justice French, and she says judicial review is not an appeal. It's not about the court considering the information afresh and coming to its own views, in this case to do with school closure. Judicial review is primarily limited to an examination of the process, and if successful usually results in the decision maker being required to start afresh, as opposed to quashing the decision for all time. And here there's people talked about winning the battle and losing the war, that generally what happens, even if you're successful in a judicial review, is that the court might set aside that decision, and it would set aside it on specified grounds. That would leave the decision maker open to go through this, to address themselves to the same issue, but do it in a procedurally better way, and still potentially come to the same decision. And that, in fact, is what's happened with the Phillipstown school case I gave you the example of. the Phillipstown School won that judicial review. It was ruled that the minister's decision was made without providing sufficient information for there to be proper consultation, and so the decision was set aside. So the minister could then go back and go, well, okay, this time we will provide enough information and we will listen carefully to you, and then we'll make our decision. The court can't make the decision for the minister. That's the minister's prerogative to make that decision, but the court can rule on whether the decision was arrived at fairly or not, and if it's not, again, this is a procedural question. So on what grounds can you conduct a judicial review? Well, there are very wide grounds on which a decision can be challenged. And again, these are not set. If you look at the Judicial Amendment Act, it doesn't set out a list of the things that you can do, and there are no forms to fill in or anything. It's not an exhaustive list in statute, but it's developed through common law application, through the courts, through legal processes, and this is how things are ruled. But they've been people have sort of broadly grouped these sorts of questions under three categories: procedural impropriety, irrationality, and illegality. There's also another common ground for challenging decisions is that the decision was made in breach of what have become known as the rules of natural justice. Now again, there are no specific written in statute passed by Parliament rules of natural justice. This isn't a precisely worded set of regulations. This is one of these nebulous things again about common law. It's not a precise thing of rules that have to be followed, but it's this evolving set of criteria that courts have come to consider to be encompassing fair process. So there's a whole range of these, and we'll go into these in more detail. But I just wanted to give you that bit of an introduction, perhaps, to get a start on this, and we'll go in a bit more detail to these particular grounds for judicial review in a moment.